In law, what you see is almost never what you get. Here's how to cut through the clutter. Hi, and welcome to the Law Simplified. I'm Shaveen Bandaranayake. One of the most important components in relation to responding to a scenario or fact pattern question, as well as an essay question, is being able to read between the lines. Oftentimes, in relation to my fast track and masterclass students, I try and impress upon them the virtues of identifying the fundamental issues. But what I have gathered throughout tutoring and mentoring for the past 8 years is how difficult it might be to decipher fact pattern and essay type questions in order to distill from it the actual problem. This video is intended to give you a broader understanding of how to look at fact pattern or problem scenarios as well as essay questions, specifically by way of an example. If you like the type of content that I make, do subscribe to the Law Simplified channel. I also highly recommend having a look at the comprehensive online law school platform, complete with theory, tutorial, and workshop lessons based on the actual one-on-ones that I've conducted for students who've gone on to achieve first-class law degrees around the world. That being said, let's have a look at a fact pattern question, see if we can break it down succinctly, but more importantly, identify the fundamental issues at hand. Let's have a look at a problem scenario or a fact pattern question. Now, this particular question for the astute students and viewers among you is the generic question that I use in most of these workshops and examples. The reason being is that this particular question is designed in a way where you can extract students who would otherwise be a pass mark, those who would be a 2-2 or a second lower, second upper, and even first class law students. There's a lot of things that are happening in this particular question or the fact pattern scenario, but what I would like you to focus on after going through the question, and take about 30 seconds to a minute to go through it in detail, is in relation to one particular area. So pause the video, read through the question, and we'll jump into the pertinent segment in the scenario. Okay, now having read through the question, you would notice that this question is on a broader context on homicide, and it's essentially a question on murder, looking into the fact that in this instance, James intended serious harm, grabbed Vicky by the throat and hit her head against a wall, killing her instantly. So in terms of an unlawful killing of a human being with an intention to kill or cause grievous bodily harm, which we can also look at as serious harm, this is clearly murder. The question then is whether there are any mitigatory factors, essentially any full or partial defenses available to James. Now, what's important to us in this context and for the purposes of this video and lesson, we will have a look at one very particular instance in this scenario, namely the fact that he pushed her away, but she would not stop and he became very angry. Now, for the most part, many students, including my fast track and masterclass students, will generally articulate the issue to go through and the issue to break down as to whether James has committed the offense of murder, which would be correct. Following that, they would go on to assess whether there is a potential mitigatory defense or a partial defense of voluntary manslaughter by loss of self-control or diminished responsibility. Now, in relation to James pushing her away and then becoming angry, the pertinent area of law is in relation to the Coroners and Justice Act of 2009, particularly in terms of loss of self-control, which is outlined in section 54 and 55 of the 2009 Act. Now, we don't have to go through this in detail at this stage, but to summarize what this particular section outlines is that where a defendant of the same sex age, and normal degree of tolerance, or the general degree of tolerance, were to be subjected to the circumstances that in our example James was, whether the outcome would be the same. In other words, we test this out against the Section 55 qualifying triggers to determine whether someone in a similar capacity, having been subjected to the similar pressures and external factors, would consider having been seriously wronged, some serious violence, or a combination of the two. Now here's where you see through the question and where you identify and try to determine whether in fact there has been a fundamental issue that needs to be tackled. For the most part, a majority of students will simply go through those provisions and then assess whether there is potential for a mitigatory defense. But how you should articulate this and how you would present it to an examiner is by identifying that this particular line is the determining factor for whether loss of control is applicable. In other words, the fundamental issue here is whether there is sufficient cause for James to feel seriously wronged, whether there was serious violence or some form of combination of the two. That aspect of feeling that emotion or feeling that reaction, so to speak, to the circumstances presented to him is the fundamental issue. Now, superficially looking at it, many students will often talk about simply whether the loss of self-control and the qualifying triggers apply without specifying why, or why exactly we are discussing that. Stating what the circumstances are would only amount to half the battle won. What you really need to do is to show the examiner why you're looking at it in that manner. So the next time that you do get a question and that you are presented with a fact pattern scenario of this nature, make sure you consider the pertinent aspects of the law and particularly where exactly it fits into the nuance of answering a question. Right. This video was intended to give you not just the superficial outline, but a more deeper meaning perspective. When an examiner gives you a question, a fact pattern or problem question, or even an essay for that matter, he or she is not anticipating you to repeat the same problem that is being presented to you. On the contrary, you're supposed to identify the fundamental issue in getting to the solution that your client, in the case of a fact pattern scenario, or the jurist, the academic, wants to assess in terms of an essay. That being said, until the next time that we meet, have fun, stay safe, and as always, obey the law.